Let's go.
Welcome, listener, to another episode of the Superman podcast. Lionel, welcome.
Thanks, Matty. Thanks for having us. We've got a special guest on today. Hopefully you can introduce her.
I will. Alana Harden Williams from Cooper Williams Lawyers. Alana reached out to us after you were bagging out lawyers the other week, Lionel. So it'd be interesting to hear Alana respond. So, Alana, welcome.
Thank you, Matt. Thank you, Lionel. I just want to clarify that I had already received the invite to participate, and I called you out of sheer terror, Matt, to ask if you were walking me into a firestorm, because I felt like I was under attack.
That you are. You are walking into
Yes.
the firestorm. So brace yourself, Alana. This is the Superman podcast.
Yeah. Well, I'm here to change your mind because I absolutely know what you're talking about, but I assure you we're not all cut from the same cloth.
So Alana's business is Cooper Williams Lawyers, boutique legal firm in Newcastle that specialise in conveyancing and estate planning. So it's good to have an expert on in that field. Lionel and I discussed estate planning a couple of weeks back.
You did.
It's
You
good to
actually
get
did a really great job.
Thank you. We'll take that. Thank you. Thank you. So I wanted to jump in, Alana, and really we spoke about the details about estate planning, like the different important documents, the wills, powers of attorney, things like that. But I wanted to get more of the personal stories, like my one recently, where I referred my parents across to you because they downloaded a form from the internet and were going to do their wills for free just from a document. So understanding from your side of things what you're seeing and, you know, the really traps that people get stuck in around this.
Yeah, for sure. And there's plenty of them. Plenty of them. Do you want me to dive into?
Yeah, let's dive in
sure.
there. Like, especially my parents around downloading something off the internet and saying, this is how I'm going to do my will.
Yeah.
Just backtrack a little bit. Just tell us a little bit about yourself, Alana, who you guys are, what you guys do, what you guys special in, and what's sort of like your common client that you see come through the doors.
Yeah, so I suppose excuse me. The first thing that you'll have to excuse me, I'm working from home this afternoon. I have a tiny human who must, just insist on being around. So he's going to go away in a second. But I suppose the first thing that I would say is my clients, there is no way to predict who's walking in the door anymore. Everyone sort of comes with their own unique set of circumstances, but, I see a lot of young couples at the moment, and I think that's because they see the value in doing it properly. A lot of people don't want to, I suppose, pay for a solicitor to draft a will for them, and they go to those online places like, I don't want to name names, but there's one particular one. Don't encourage him, Lionel or Matt. There's one particular one online that does a heavy amount of advertising, and I suppose the first pitfall I see with that is that they don't actually offer any legal advice. So it's like, tell us who your executor is, tell us where you want you to do who you want it to go to, and it's literally filling out a form. They don't actually tell you about the intricacies of will drafting. So things like, what is your contingency plan? What happens if your children predecease you and they have children? They don't talk about, I suppose, the super side of things as well, which traditionally we would try and keep out of an estate. All of those bits and pieces are just absolutely missed.
So they're more order takers, you would say?
Yeah, absolutely. It's like going to a takeaway. I think that's a really good way to describe it. So I suppose the second thing I see when people pick up a will kit from the post office, for example, is that it really does require some proper construction. So there's certain language and certain things that you would really be looking for that would make a will spin. And failing to do that can cause enormous problems for your family and loved ones when you do pass away and it's time to administer the estate. Some people will have their beneficiaries witness a will, which, is just 101 not on, but they don't tell you that in the online things. It makes your will, what can make your will invalid if your beneficiaries are witnessing. It's also a requirement to have 2 witnesses, not 1. Full signatures, you can't initial things. The amount of will kits I've seen from a post office or similar sort of thing that come across with like initials, I'm like, what do we do with this? It's not properly executed.
Different dates from the
Different
witness to the.
dates. Sometimes they run out of room and they squeeze it in. And I'm like, I'm not actually sure what you're trying to tell me here, because does that go with this point or that point because there's not enough room? And I suppose like then there's other things like people wouldn't recognize this because it's more of a case law, but putting staples through wills is like an ultimate no-no. You don't put staples through a will. When it goes to the Supreme Court for probate, they will question whether one page has been taken out and replaced with another, because you can see the indents from where staples were. So it's not to say it's absolutely going to make your will fall over, but it's certainly going to cause at least one headache for the family or the executors. And so they're all the really key things that people overlook when they're looking for the cheaper version. But I suppose like when you draft it with a solicitor, one would hope that you're getting a really well-serviced product and that you're going to have very minimal, if not no problems with the will. But yeah, I also accept that everyone thinks they can draft wills and it's quite easy, and it's not. Yeah. And that's kind of where I've really focused my work on, because I love paperwork. Like it's my thing, and I really get a lot of value out of helping people set things up, and working with people to make sure that we're getting what they want at the end of it as well. So yeah, I suppose they're the biggest problems. No advice, execution, construction. There's all little bits and pieces that unless you sit in this space regularly, you just wouldn't know.
So what would fall into a basic will? Like what are the type of things that they put into it, and how is it executed? But then at the same time, on the back of that, when shit hits the fan and you have to actually go and use this document, how was it used? And then also then talk about maybe what a good will would look like and how it's executed.
Yeah. So I suppose for a basic will, you would want to see an executor. You'd be surprised how many people will do a will without an executor. Now that's
just when you talk about all these words and all that sort of stuff, just simply explain to the listener what it actually is from a legal.
What's an executor?
Yeah. So you beat me to it. It is the person appointed under the will to administer the estate. So they're effectively the person who is putting into action whatever it is that the deceased has said they want to occur. So more often than not, you will see a family member doing it, and it doesn't need to be one person. It can be 2 people, 3 people. I, from a professional perspective, would discourage a number of people being the executor, just because you can end up in a scenario where you've got too many chiefs and not enough Indians, and it just can be really problematic and also slow down the estate process, which, can take quite a while anyways. But then if we're looking at the will, once we've got our executor, and so whoever's in charge, a really basic will would sort of say, well, when I pass away, this is who I want to benefit from my estate. And then you might have some names. So traditionally you might see partner. So if they're in a relationship, it might say, I automatically transfer the balance of my estate once I've paid all my debts to my partner. And if they have predeceased me, really commonly it might say to be split equally between my children in equal shares. It can roll on. You would want to see that roll on. So I would be then having the next question, even as a part of a basic will, it says, well, if your children or a child of yours predeceases you, do you want their share to go to their kids if they have children, or would it be absorbed into the estate and divided between your children who are still alive? And that I would think is a pretty basic will.
And then what are the troubles that you, like, for example, when someone passes away, if you don't have a will, then it goes to probate, is it? Or goes to
Yeah,
the
it goes to letters of
goes to the
administration. Yeah.
administration? Yeah.
Yeah, so that you go through a process with the Supreme Court that appoints someone effectively to be in charge of the estate, and then it will follow the process set out in the Succession Act, and everyone's family situation is going to look differently. So, you know, there's an underlying presumption if you're in a nuclear family that if they die in the and don't have a will, that the surviving partner would take the estate in its entirety. If both parents had they had passed away, for example, and there was no will, go to the children. That's pretty standard. The Succession Act also covers things where you might have separated parents and they're remarried, and it will provide a bit of insight into, you know, what that would look like as well. It's not, it's a scary process to have the government say this is what happens, especially because I can near guarantee that when one of these scenarios comes up, that someone's going to have a problem with it. So the most common problem I see is, well, that's not fair. Mum and dad gave whoever $100,000, that should come out of their estate. That should come out of their portion, sorry. And there's no way to, you know, absolutely determine what should happen in that space because you don't have a will that covers that off. We maybe don't have a letter accompanying it in a will packet, which I usually advocate for when I'm having these conversations that, you know, are pretty challenging when people are saying, I don't want this person to have X, Y, and Z. I'd be like, well, you know, they're eligible for a family provision claim. And if you really are feeling this way, this is the scenario that we're going to work with it. And I would like, you know, whatever it is, you know, you have to tailor your advice around people, of course, but there's a lot of case law around, you know, affidavits or statutory declarations for when you're excluding someone from a will. Some people, in a previous scenario, is we decided that a good practice, you know, not necessarily for the view of court and litigating and family provision claims, but a client of mine really was adamant that they wanted it in their handwriting and it to be a letter to explain to the particular person why they had been excluded. And so that was a part of our estate planning management. They felt that that was a really strong and powerful way to manage a claim. And so whilst you give advice, you always have to take on board what the client thinks would be helpful as well, because at the end of the day, I can give all the legal advice under the sun, but family knows family. They know how they're going to react and what's going to work and probably what's not going to work. Sorry. So yeah, that's...
So with the ramifications of not having a will, someone's going to say through the Succession Act, it's going to say this person should get this and that person get that, and the government's really determine who gets it. But and usually what happens in a dispute usually is someone's not happy and
Absolutely.
someone wants something else. Who pays for all of that?
Your estate, generally.
So the person who's died, they've got all their money in a pool, and then the estate's going to be paying for who? Legal bills for
the legal
both
bills to
sides or one
defend.
side?
No, so for the person who's defending the estate or defending the claim, knowing that that's not what the intention was, that will come out of that. The other person will pay their own legal fees, but of course, I suppose you end up in a different territory if it gets absolutely before a judge and they have to make a decision. There's always an allowance in some circumstance for a cost order. And if that was to happen, I suppose I would expect that there might be a direction for them to see that the estate pay that as well.
So the estate pays everything.
They can, yeah. If they're unsuccessful, though, it's highly unlikely that the estate would be paying for it. But if there was the prospects of success, I would think that that would be the natural course of action from any solicitor worth their salt.
So the cost, sorry, Lana, the cost of not having a will. So when the government decide, do they charge the estate anything as well to do their work?
So the answer is it depends who ends up at the helm of it.
Right.
So if you had a family member jumping in for letters of administration and they were all going to do it, they're not, that the estate is effectively going to pay for that process. And the government doesn't come involved per se. It doesn't end up being litigated. You don't end up in front of a judge. It's simply, well, we're applying for letters of administration. This is, the documentation that supports it. And then the legal practitioner then becomes the person who has to sort through that and divide it up in accordance with the Succession Act.
Gotcha. Okay.
Yeah. So it would only come about if it became contested once more.
Yep. But there may be additional legal fees than having it written correctly.
Yes. So that's probably the biggest thing is people say, I don't need this. It costs too much money. And I think to myself, yeah, I can understand why that, in today's day and age when things are so tight, but it will far, far exceed the cost of a will for letters of administration to be applied for. In some cases, the filing fee would be more than a will. So, and
what's the filing fee? What's that mean?
So that's when you apply to the court to lodge an application, generally. So they all say, well, family court, Supreme Court, even New South Wales Land Titles Registry. When you want to apply for something, you pay a filing fee. So basically it's a fee that you pay to the court to get your records on file or to make an application to start proceedings.
That's just to get started. Usually costs more than a basic shitty ass will from the post office.
Absolutely, it does. And they change. They are, they change on the 1st of July every year, and without a doubt, they go up. They don't go down. So I'm predicting that in 11 days, 12 days, that the fees for every government organisation going are going to go up a little bit.
Well, that's nice.
Yeah, it's great when I have to have those conversations.
Someone's got to pay for it, and in our conversation today, it's the estate that pays for all this fighting. So
honestly, it's sad. I really focus on drafting a well-constructed will, so we don't aim to not be in these situations. But families are really challenging at times as well. It is really important because it's more the headache, it's the sadness that you see in families as well, because they're dealing with loss. And then you add on top of that confusion around, well, what's going to happen? And it can be really quite grim and a lot of hand holding in that space because, they don't know what's going to happen. And they thought maybe that mum and dad did have a will. So it's one of those scenarios where you say, well, yeah, it could cost you $300, $400, $500 to get this sorted. But I guarantee that if you put that in perspective to what it will cost the estate and probably the headache that it will leave your children, the value is there.
So how much would a whole package, estate planning package,
a suite?
A suite, as you will. For say a couple in their 30s, 2 kids, to do the will, powers of attorney, maybe joint guardianship as well. How much would something like that set someone back? Like, just give a range, because I know everyone's completely different.
So I would think if you were doing like a full suite, and that would include what's now pretty common in practice is an advanced care directive. So you might get 4 documents: a will, an advanced care directive, a power of attorney, and an enduring guardianship, and 2 of each, so 8 documents. You could look at a couple of $1,000s for 8 documents. Like, as a ballpark, I know there's a lot of discussion, well, internally within me, but amongst other people as well, just trying to always get a sense for what seems reasonable on price, because it's such an important thing to have in place, but you can really box people out of the market too if you're not sort of offering a service at a price that is at least somewhat accessible to most people. And I've certainly worked at places, in the past where they've had, set fees, and then other places that I've worked haven't had set fees. It's kind of like, well, you tell us what you want and, we'll give you a range. So, yeah. Yeah.
And then a retired couple, because Lionel and I got lots of retirees. What would they be looking at? Because they're not having that enduring guardianship as such. There's probably one less document.
Yeah. So I'm an advocate for bundling things up, right? I just think that if you can get something happening and bundle the prices together, I think that it should sort of lower the cost, because realistically, if you're taking instructions for one, you know, you might as well take instructions for others while you're there. So presumably if it was, and I'm also a sucker for an old person as well. I have a real soft spot for the oldies, if I'm being entirely honest. They just bring me far too much joy in life. So if they were to flash a pension card in front of me, I'd think that that would do them wonders.
Don't be deceived by that pension card, I can tell you that.
Yeah. They're just good value. I just think they bring such a little bit of fun to my life anyways. But I would think that with that in mind, their needs are probably far less. We're not factoring in kids. We're probably not factoring the fact that a lot of them are coming with mortgages, you know, presumably there's
simple,
really simple. I would be thinking, like, if they were doing less, you know, and there was two of them, I don't know, it's hard to say. Everyone surprises me, but if you're saying a couple of grand for 8 documents, you'd probably be looking at a bit less for 4 or 6, I suppose. I don't know. Hard. It's a case-by-case situation. I really need to sit down and probably reflect on that a bit more, hey? Because it is
Speaking of the oldies though, and having stories, I think we had one together recently. Lionel, Alana and I were sitting down with a client, and the client was calling his best friend and his executor Sol. And we're like, what's his real name? And the guy's like, oh, I'd have to check what his real name is. I've just called him Sol for the last 30, 40 years. And Alana's like, how did he get that nickname? And he's like, well, I just shortened asshole to Sol. So he's been calling this guy Sol because he called him asshole for 30 years.
And what a,
that is amazing.
But, you know, the conviction when he said it, amazing. But also, what a rookie move from me to ask a question like that.
Very true.
Seemed innocent enough. But but that's the sort of example of, like, you know, old people are just great. Have a lot of time for them. So, and a lot of people don't. They get frustrated by it. I think they're great. There's a very big place for them in my practice, that's for sure.
Yeah. And then I think we're going outside the scope a little bit. Like we've done work together on things like granny flat arrangements as well, Lionel. Different things where there's arguments starting in families before anything's actually agreed on. So having agreements in place, legal agreements. Have you done many of those, Alana?
Yeah. Yeah, I do a bit. And I suppose, like, the rise of the granny flat is huge. And it's interesting because, like, the Law Society Journal, you know, will find what's really topical and write about it. And I did notice there was something about granny flats that came out last year, and it's on my to read list. But it's funny when I reflect on, you know, time past, because that wasn't a thing. So I remember when I was first admitted as a solicitor in 2015, and what was really, really standard practice where I grew up, which was in a small town, was that wills were being drafted, but not taking into account the granny flat. It was moreover that the practice at that point was that mum or dad sold their house, moved in with their kids. They used the proceeds of their sale to pay off the family home, so to speak, and basically they had a right of residency until they died. And that was, you know, a big thing and really normal. And now it's about, okay, well, let's do granny flat agreements, and it's turned into, you know, deeds of arrangement and that type of thing. So it's quite progressive and it's quite interesting. I do see a lot of scenarios like that happening as well now, which is kind of cool, I think. Maybe they're done and done right.
They're getting the advice early rather than blowing up families over money, right? Which we've all seen far too often.
Yes, absolutely. Scary stuff sometimes.
It's more destruction than it is anything, to be honest. Like someone passes away and then they've lost one person, and then it's destruction because the next person they're going to lose is their person that wants money for a certain reason because they didn't know and they think they're entitled.
Yes.
Hey, Lana, can you peel back the process? Like when someone passes away, because a lot of people don't really know what happens when that does happen. What is the actual process? Like someone passes away, you get a death certificate, and then all their estate, their assets go into where? Is it into like a bubble that sits up here and says, "Oh, here's all your money over here," or what actually happens?
Yeah.
Who's
So
the person? Yeah, who's the person that does or the administering? So, for example, when you do have a will, and the reasons for you having a will is because someone goes and administers it. Who is that person that administers it? And at the same time, what happens part of the process along the way? How long? What is it? Who do they contact? How long does it usually take? And just sort of walk us through a simple process in general terms to explain it to our listeners.
Yeah, for sure. So I suppose the death certificate is usually received by the family as a part of, when they're doing the burial arrangements, and the funeral home will largely put them, in touch with that. And so then the next step would be for most families to contact the family solicitor or whoever drafted the will or someone separate. There's no actual need to go to the solicitor that drafted the will to administer the estate. Yeah. Yeah. So it can be really helpful.
Yeah.
Because obviously they've got an understanding of what the intent was. So if there's any question mark around it, you've got the file notes, you've got all that sort of stuff. But you would get that death certificate. You'd then line up the executor or the executors, so the people that, whoever's passed away have appointed, to come into the office and say, well, listen, we need to organise these documents to apply for what the Supreme Court calls probate. And probate is pretty standard. So you apply to the court to get probate, and basically that's approving.
What is probate? But why do they call it probate?
I don't actually know why it's called probate, but that's a really good question. I'm probably missing something huge there, Lionel. But it's a court order basically that says we've got the will, we've got the original will. You've absolutely convinced us that the deceased is deceased. We've seen the death certificate and that you're appointed to administer the estate. So then they send back that grant of probate, and it's effectively just a piece of paper with a court seal on it, and it gives you the permission to then go and organise the estate, so to speak. So, they have to sell the house. They've got the permission to sell the house. If they've got money in a bank account, it gives you the permission to go and close that bank account. They've got shares. Okay, let's sell them off. And then largely what would happen is we would bring that money in from the sale or closing of the accounts or whatever it is, and we would pull it into the solicitor's trust account. And so simultaneously with all this, we're notifying organisations like maybe it's Energy Australia, maybe it's Hunter or Sydney Water, simple things like the pendant necklaces with the duress alarms. We're notifying them that that the deceased is deceased and that we're sending these things back and send us a closing bill. So as the money is coming in, we're notifying everyone else to say, this is what's happened. We need to close the accounts, send us any outstanding bills, and then we pay everything off.
So you pay everything out first, all the debts are paid out first.
Yes,
that's
absolutely.
One of the big things that people miss with estate planning and wills and shit like that. Or the estate is a big pool of money, but whatever the estate or that person endured in terms of debt needs to be repaid first. So
absolutely.
The creditors need to be paid back first. That's a pretty key point to point out there.
And that's why it happens that way. And it's really good to have a solicitor, because at the end of the day, those creditors are not going to stop. And it's certainly going to become a headache for the executor if they're continually banging on the door trying to get money and you've already given everything away.
Yeah. So we counter that sort of stuff with for financial planning. One of the sayings is your creditors are your first heirs to your estate. When they talk about insurance, and then when we're talking about, you're welcome. when we're talking about insurance, one way to get rid of all the creditors first is to put life insurance in place. Is what the planners would do. But yeah, carry on. So the probate is granted, and you're administering all the affairs.
Yeah. So you're pretty much notifying everyone, saying send us your bills.
Yeah, and then the will pretty much is. And how long does that usually take? How long does probate take to receive probate? Like, why does it take longer for some people and quicker for other people?
Well, I suppose there was a really lengthy wait period over COVID. And so we saw really long wait times for it to come back. And I'm actually not sure what the cause was around that. But I suppose that, sorry?
Does anyone know?
Anyone know anything about? I feel like I just lost that 3 years of my life, Lionel. Just look back and go, it was somewhere in there.
Yeah.
But yeah, we saw long wait times over there. I assume it's just a backlog that they can't get on top of things because someone's got to go through the documents and approve it, put the court seal on it. You know, they've obviously got to verify the death certificate and all the information. You know, there's a lot of boxes to be checked on their end before they sign off. So there's no way I think we could accurately say how long it's going to take, but realistically, if everything's organized, you should be able to apply for probate pretty quickly, right? You should be able to say to your solicitor, we have to apply for probate because we've got a property. You know, if your estate has really minimal assets, it's probably a really important thing to say. If you're dying without a property, if you're dying with like just a little bit of money in a bank account, you know, or very minimal stuff or assets, you probably won't need to apply for probate. But the minute that you start dealing with big things like property, you just automatically have to do it. So historically, some banks would allow you to take money out of someone's account if you could verify that they were dead, if it was less than $50,000. So you didn't have to apply for probate. And if you could do it that way, that was the preferred way to do it because you pay a filing fee for probate. And what's really quite scary about this is the amount is scaled against how much the estate is worth.
Oh.
I know, horrific. Oh. So when people come to me and say,
are they doing more work or less work for this filing?
It's pretty much the same work. You might just have to divvy up more in the end. Yeah, like it's not. I don't think it would make. Well, this is the thing, right? So if you can avoid it, and when we're talking to people about keeping their superannuation out of their estate, my immediate thought is if you can do that, I really think that it's important that you consider that that's a valid option here because you might go from $1,000 to $2,000. And that $2,000 is better off in your kid's pocket than what it is with, no offense, New South Wales Supreme Government, you know, state court or whatever. We're not interested in lining your pockets. We want the family to have it. So like but that's, you know, neither here nor there.
You really feel.
I see. So it's from my perspective, I 100% believe in the Supreme Court, but do I think that there's merit in that? I don't understand how they scale it. Someone could explain it to me. I'm happy to, you know, be receptive. But to me, it would theoretically be the same work.
Yeah.
So yeah, doing it like that is preferred. But of course, like going back to applying for the probate, you do that, you're paying everything off. And I would probably say just in terms of proper management of a client, I would be saying, listen, if you haven't heard back from me in 6 weeks that it's not received, I'm going to mark my calendar and follow you up, but by all means follow me up because by 6 weeks, I would have expected it should have come back. You should have received it back from the Supreme Court.
So call it 6 weeks and then the sale of assets after that period.
Yeah.
Which could be anywhere from
anyone's guess
3 months to 6 months.
Yeah. Because you can list a property for sale before you have a grant of probate, but you have to do it subject to you have to have a special condition that says subject to probate being granted.
Yeah.
Yeah. And so like you can do things on the side that facilitate this happening, but
keep everything moving.
Yeah. But good practice says that we wouldn't be looking to finalize the estate and close everything off until probably say 6 to 12 months after the person has passed away, because by that point your annual fees that you might have been paying for something you should have received that in the mail. So we'll quite commonly put a redirect on as well that sends any of the deceased mail over to the office. And so we're collating all of this information, making sure that nothing's going to come up for $100 or $200 bill, you know, after we've paid everyone out. And that's just sort of what it would look like. And then, of course, once we've paid all the dues off, we then go, well, what does the will say happens to the balance here? It says that, you know, 50% goes to my daughter Cindy, 50% goes to my daughter Marsha, and that's it. We're all done. And my superannuation goes to my daughter Jan. You just divide it up in that way that's directed. Then it's done.
So that's
yeah. So 6 to 12 months general rule of thumb.
Yeah.
Start to finish with no hiccups or
no hiccups. Yeah. That's probably the key, Matt. Like, and of course, like one of the things that's kind of lost on people when they're drafting a will is when you're choosing your executor, you have to pick someone who is going to be proactive. So them being proactive in the process is really important because they will be expected to sign off and do some of the legwork.
And this sounds like a lot of admin as well. So good admin and detail. As well.
So like it's important that you don't pick your kid who, you know, hates that sort of stuff or is really reluctant to duck in and sign off on X, Y, and Z. You need someone who can do it and actually, you know, want to do it. Otherwise it becomes really quite burdensome. And what I sort of see on the back end is the other siblings or the beneficiaries saying, where are we up to? And you're sort of sitting in a space where it's like, well, I've kind of been calling for 2 weeks and I can't get them to come in and do this, or I'm still waiting to hear back, you know, whatever that looks like.
Speak to your brother, speak to your sister.
100%. And you sort of get triangulated and you feel pretty awful about it. But what do? You're at the mercy of the will.
I think the other thing I wanted to touch on, and Lionel, I think with your clients as well, is the collaboration between lawyers, financial planners, when building out an estate plan, like looking at the distribution of assets, how it all falls, the tax side of things, superannuation, to make sure, even insurance, like Lionel said, even equalising an estate, that we've had one at the moment going through. Just how important is that from your side of things to get things right the first time around when you're drafting up all their wishes?
I can't stress to people enough, and it's like you know, they look through me. I'm not allowed to give financial advice, nor do I want to give financial advice. I am a solicitor. You know, if I was good at numbers, I probably would have a really different job. So like I see that there is a real value in having conversations and collaborating, you know, even with accountants, because quite often as a part of an estate as well, if you're looking at like the estate process opposed to the will process, you need to do a tax return for some if they die in the, you know, in their working life, for example. But moving into like even their later years, I'm not going to have the ins and the outs and the know-how that, you know, you guys would have in terms of financial planning. And like even listening to your previous podcast, because I do listen to them.
Thank you for our review as well. Thank you.
You're welcome. You're welcome. Like I certainly gain things from that because my background is not dollars and cents. It's not. And I would be doing my clients a disservice in pretending that I know the ins and outs of that. I can document an agreement. Absolutely. I can tell you about how a will operates. I can do all of that. But can I tell you about the tax advantages and tax incentives and the ins and outs that you guys can because you sit in that space every day? Absolutely not. I can tell you about the legal implications of it for sure. Can I tell you about money side of it? Aside from the basics, of course.
Yeah, I think that's important because some people thinking about when you're distributing your assets to different kids and different parts, the tax implication of leaving super to an adult child compared to leaving a property that might have capital gains tax to be paid on it. Like all these different scenarios that need to come into account when looking at the plan about, well, what's going to be best for which beneficiary and all that type of thing.
Yeah, for sure. And everyone's circumstances are going to be different. Like I've certainly done wills in the past, where a big part of the work is, okay, well, I know that their child is in the receipt of, a particular pension. How much can we gift them without it impacting that? And a lot of people probably wouldn't go to that effort to make sure, but I know that when you're thinking about a child with a disability, you're not going to want to leave them with potentially no parents, no support, and no income. You're going to want to make sure they have some sort of consistency there so they can take care of themselves. But I think that's probably what divides some practitioners from others, is the level that they get involved in learning about people's circumstances.
Yeah, I think it's more the advice piece as well that you provide, rather than, as we mentioned at the start, more order takers or that are just writing orders as such.
100%. And I have like checklists that I'll run through, and they're just like embedded in my brain. Do you have children of a previous relationship? Have you finalized that divorce? Tell me about your company structure. Those sorts of things should be indoctrinated in you if you are worth, doing this for them. It shouldn't be that cookie cutter, hey, we're doing X, Y, and Z, and here we go. And then the will is, you can't actually make it turn into, the grand plan that it was supposed to be, because, corporations law says no, or, how many times I've seen wills where people have gifted something they can't actually gift. Shocking. And I think to myself, how did that solicitor let that happen? There's no right of survivorship on that property. Why would they not ask how they hold that property? And I'm just mind blown sometimes. But hey, here we are.
Here we are. There's
Here we
a mixture of professionals that sort of do it their own way, but but you do it. Sounds like you do it pretty well, Alana. Maddie has spoken very highly of your service and how you sort of deal with people.
Thank you.
That's the sort of the pinnacle of a great relationship, is someone sort of giving some good advice and referring and stuff like that. And at the end of the day, the professional, each professional is going to use each other because it makes their life easier.
100%.
When you can communicate the complexities of someone's situation, and from a financial planner's perspective, I think we simplify it and dumb it right down to make it help people understand what they're actually getting into and why they're getting into it for. That's sort of one of the big things with collaboration, is sort of like, we understand the intricacies of their relationship with themselves and their money. And then we can sort of relay that back to you as the professional or the legal writer, and sort of construct this document to make it as sort of safe as you can without having too much interruption with the legal side of it. And I find in the legal process is sort of, it's creating a document, but it's also spelling out to people that are in receipt of it what your actual rules are, what's your playbook for your wealth, and how you want it to play out, and what you want it to do, and all that sort of stuff. So having a decent will in place makes sure, just sort of gives them a rule book on what your expectations are for your estate and who you want it to go to. And it sort of not mitigates, but it stops the headbutting of the disputes, what I mean? So
yeah, that's the worst part in wills and estates, is the disputes. If you can minimize it, why wouldn't you? Because at the end of the day, it's only going to end up on your desk in 10, 20 years time potentially. So I think you're mad if you don't get in front of a problem. So I'd be inclined to agree with the process that you're taking, Lionel.
Yeah. So I advocate getting your estate planning, getting your shit sorted to make sure
getting your shit sorted.
You know what? There's no better way to say it.
That's as simple as it
I'm
is.
glad you can say it. I feel like if
I'll say it.
It's hard though, because like I can tell you, like, from my experience, when you're watching things plummet in front of you, and it could just be around, we don't know what they wanted, or we don't have this, it's going to cost so much money, X, Y, and Z, or mum doesn't recognize us anymore, we can't have the grandkids go, we don't know if she wanted to go into palliative care. Like, you see that.
Yeah, it's very sad.
You see that happening, and it is it's not nice for your family. And I think if you can sit back and go, listen, these are the scenarios I want to avoid, a lot of people will change their mind and probably pony up and get into an office and draft a will, because you do need to put yourself in those people's shoes. Go, what's this going to be like for my kids? What's it going to be like for my grandkids? You know, probably not great.
Well,
thank you, Alana. Thank you for sharing your expert knowledge with our listeners. Feel free to send your invoice across the line.
We're not all bloody ambulance chasers, Matthew. Calm down.
That's good. That's good to know. Hopefully, Lionel, hopefully we know, understood. It's not all lawyers, mate. It's not all lawyers.
It's not all lawyers. Not all lawyers.
There are a couple, though.
There are. I can't stand here and pretend there's not. There definitely is.
Yeah. So if there's any listeners out there with any other questions or need to get their shit in order, feel free to reach out to Alana at Cooper Williams Lawyers in Newcastle for your estate planning needs. Anything else, Lionel or Alana?
Just use the Superman podcast discount code and you'll get 20% off.
Flash your pension card, guys. I'm a sucker for an oldie.
It sounds like you get more off with a pension card.
Thanks, Alana, for jumping on. We really appreciate you taking
Thanks for having me, guys. Thanks for letting me waffle. See you later.
Cheers. Thanks for that.
Bye.
Bye.